Yes, Lord Everard.
My lords, my ladies, so I like to go back to some of the questions that have been put to me, and in particular, there were questions from both Lady Justice Andrews and from Lord Justice Popplewell on the effect of an agreement by the parties to, for example, admit a late objection or to agree different rules. And what I should have done at that point was to take your lordships to another key provision in the Act, which is, of course, Section 4. That's Volume 8, Tab 55. LA, Tab 55, page 1. And the Act is very clear. It says the mandatory provisions of this part are listed in Schedule 1 and have effect, notwithstanding any agreement to the contrary. The other provisions of this part, the non-mandatory provisions, allow the parties to make their own arrangements by agreement, but provide rules which apply in the absence of such agreement. The parties may make such arrangements by agreeing to the application of institutional rules or providing any other means by which a matter may be decided. So the clear analysis suggests that if the parties reach an agreement on the timing of the objection that is incompatible with Section 31, they're doing something which could create quite a lot of problems later on, because Section 31 has effect, notwithstanding any agreement to the contrary. It's not the problem that affects my case, but it's a very important conceptual question that really informs the whole analysis that I've tried to present to your lordship, your ladyship, on Section 73 and Section 31. So I think it is important to have that in mind. Now, on the scenario of the parties agreeing... Yes?
Section 73 is also part of Part 1. Yeah. But that doesn't mean that an arbitration agreement within the meaning of Section 73 can't extend time, does it?
I think my answer to that sort of goes back to a point that I said in response to a question from Lady Justice Andrews. I don't need to take the extreme view that all of the language of Section 73(1) falls away because we have a provisions of this part. But I do submit that all of that language is subject to a mandatory provision. So an arbitration agreement that allows to extend time may do so subject to the mandatory provisions. So all of those exceptions...
I don't understand what you mean, subject to the mandatory provisions. It can or it can't. You can, for Section 73 purposes, you can, in an arbitration agreement, agree to allow further time or not?
For purpose of Section 73, if the agreement is contrary to 31, you can't do it. As you can't agree to rule out or to contract out of Section 73. It's a mandatory provision. You can't contract out of a mandatory provision, whether it's Section 31 or Section 73. Neither party can do it. And if they do it, they can get themselves into real difficulties. There may be waiver points that could be relevant in that sort of scenario if one were to pursue it, where the parties have, for example, indicated to the tribunal, look, you can really deal with this objection. We both agree that even though it's late, we want you to deal with it. So there may be other points, but ultimately the mandatory provisions must be given effect, notwithstanding any agreement to the contrary. And so arbitration agreement in Section 73 must mean arbitration agreement insofar as effective, read together with Section 4. An arbitration agreement that seeks to contract out of mandatory provisions is not effective. There's no, on our case, other possible reading of arbitration agreement in Section 73. It is all subject to, because it's the general scheme of the Act, to the mandatory provisions and to the proviso that the parties can't contract out of those provisions. And I completely accept that that can give rise to some difficulties at the margins. So that's our answer to the effect of the agreement of the parties, and the reason why for the paragraph A objections, we keep going back to Section 31, because it really is the provision that controls how the timing and the filing of the objections is supposed to work. I also wanted to go back briefly to the point about prejudice. You know, what prejudice could we say to have suffered in terms of the objectives and the purposes of the Arbitration Act by having to relitigate this point? And I think I'll just take you briefly to the rejoinder SB, that's Supplementary Bundle, tab 18, and it's page 251. So this is the respondent's rejoinder. And in those three paragraphs, 472 to 474, Supplementary Bundle, tab 18. I don't know if this is one of the printed documents. No, it isn't one of the printed documents, I'm afraid.
No, we've got paragraph 471.
Oh, right. Okay. So this is simply to say that the prejudice that we suffered is that in these three paragraphs, it's really 472, 473, and 474, the claimants established a beachhead, which is what they're now using to expand into this whole world of objections that we've been dealing with. So that's the prejudice that a party that is faced with an objection that the other side says it wasn't even new can have to face before this court, having to relitigate all of these points, because all of the issues that we're dealing with really arise allegedly in those paragraphs.
That's my fault. I'm not quite understanding. Is your point that in the rejoinder they did take this jurisdictional objection?
Our initial point was that they hadn't even taken it properly in the rejoinder, but this is not a point that is open to us to reopen.
So
but there is one issue.
I don't understand how you say there's a prejudice in the operation of section 73 in this case.
I think the prejudice is if one doesn't take a strict approach to the loss of the right to object. And so if a party manages to sneak in some appearance of an objection.
They're not just sneaking it in, they're raising it perfectly frankly, and you and your client say, yes, please tribunal, will you deal with it?
We didn't say that. We said it's a new objection, and if I can come to that actually, because if the comment by the tribunal on timeliness, if the court is inclined to view it as quite important in this factual matrix, then I think it is important to really see what that comment referred to. So if I could give just a few brief references to really understand what that timeliness comment was about. In our rejoinder on jurisdiction, so if we can now move to Supplementary Bundle, tab 19, page 27. Yes, so paragraph 64 is where we say the respondent has raised a new objection. The heading that we are considering is the investor point. So it had seemed to us from those two paragraphs that I take the court briefly to before, that the point was about the investor. And we say that point is new. The tribunal, if we now go to the award, Supplementary Bundle, tab 23, page 100, the tribunal is dealing with, we see it from the heading, again, the investor point. And it is in that context that the comment in brackets of paragraph 310 appears, where the tribunal says no timeliness objection. So insofar as this timeliness comment by the tribunal is an indication that the court considers has some weight in understanding how these provisions apply, it is important to appreciate that it was all in the context of the investor point rather than the Stava June 2011 point. Now, our principal case is, of course, that the timeliness comment can't fix the problem that the Czech Republic has with Section 31.3. But I thought I would mention that point as well. So, my lords and my lady, I have set out our case on the interpretation of the relevant provision of the Act in this case. there is a case that is put against us, which is essentially a statutory waiver point that is taken against us. So the Czech Republic argues that our position on section 73(1)(a) is in some ways neutralized because we failed to object to their lateness. So their case, if we can go to these provisions, section 73, which is page 13. So the argument seems to be that by failing upon the receipt of the rejoinder to mount a challenge to the lateness of the objection, we put ourselves in the position where we failed ourselves to raise an objection promptly. And the objection that it is said we ought to have raised is said to fall under either paragraph B, C, or D. So in effect, the argument is that we have waived the right to raise the point about them having waived the right under section 73(1)(a).
Or put more simply, you're taking a timeliness objection. It's a necessary part of your argument, and that wasn't an objection you took at the time.
Yes.
So the objection we're talking about is a timeliness objection.
Yes, so they say we didn't take an objection under, and so we are caught by 73 as well in our failure to respond.
I mean, your objection is that they failed to take the point on time, and you say they failed to comply with section 31. So they say, well, that's whatever else that may be, that is an objection, but there has been a failure to comply with a provision of this part.
Yes, now our answer to that is that all of those objections are objections that go to the tribunal. We are not saying that section 31(3) was not complied with by the tribunal. On our analysis, the tribunal did what it could perfectly well do, which is determine an objection. The tribunal did not make a determination of admission on the basis of justified delay because no one had asked the tribunal to make that determination. The party that should have asked the tribunal was the Czech Republic. So we have...
Going a bit too far, so I'm not quite answering. So the kind of objection you say that falls within section 73 is an objection that is made to the tribunal, or isn't an objection that's made to the tribunal?
So to take it in steps, their objection clearly falls under paragraph A of section 73 because it is an objection to the substantive jurisdiction of the tribunal. I don't think there is any dispute on that. The point is, where do we stand in respect of our alleged failure to have raised a point? And I think all of those paragraphs B, C, and D points are taken against us. And our answer is that our failing to point out to the Czech Republic that they should have put in an application is not an objection that the proceedings have been improperly conducted. We're not saying the proceedings have been improperly conducted. We're just saying that if they want to preserve a certain right to relitigate the point later on, they have to do it in a certain way. But that's not an...
What you're saying is that the tribunal is dealing with a matter that wasn't properly before it. So why isn't that a complaint that the proceedings weren't properly conducted?
Well, my lady, the answer to that is that the tribunal can deal with any jurisdictional point that is before it, and it made this jurisdictional determination, but that it did not admit the objection. So we distinguish between a determination by the tribunal to admit an objection on the basis of justified delay and a determination by the tribunal on the merits of the objection. The tribunal can do the latter, even if it doesn't do the former.
How can it do the latter if it doesn't do the former? Because if it doesn't do the former, it's not seized of jurisdiction to deal with the latter. This is totally elliptical logic.
Well, no, because I think under section 30, which is at page 2, it has the general competence to rule on its jurisdiction. So if there is a doubt that the tribunal has about its jurisdiction, whether the point has been advanced by a party as a properly put objection, the tribunal can rule on that point.
But once you make that concession, I think you're in difficulty. as a matter of complete logic. Can't see how once it's competent to rule on its own jurisdiction, irrespective of whether a party has raised an objection, you can then turn around and say, well, you're shut out from raising the objection.
Well, we distinct.
Because you didn't ask for an extension of time at the time.
Well, my lady, that is our case. So the tribunal.
I'm just struggling to grapple.
Yes.
with it.
Well, if I may, the tribunal has the competence to rule on any point before it or not before it, or any point that crosses the tribunal's mind. And the party, if it wants to raise the objection and preserve its subsequent right to relitigate the point, has to do it in a certain way. And it has to invite the tribunal to exercise a specific discretion that arises under the statutory regime in section 31(3). If the party hasn't done it, it's not the problem of the tribunal, it's the problem of the party. The tribunal, if it feels it still wants to decide the point, it can do so. And that's on our case the way in which these provisions should be read. So we're not taking aim at the tribunal. If, however, the tribunal had said in the award, we have admitted this objection and have established justified delay, then perhaps in that case we might have been in a position where we could have had a section 68 problem with the award, because we would have said, how could the tribunal make this determination without inviting any submissions from us? This is not where we are, because in our case, there was no exercise of the discretion by the tribunal under section 31(3), notwithstanding the fact that the tribunal determined a certain point. That's our case.
Right.
On the argument put against us about us having waived the right to dispute.
Well, that's B, but what about C? It is part of your objection, isn't it, that section 31(3) was not complied with. If I understand your argument, section 73 can only be interpreted as time having been allowed if time has been allowed in accordance with section 31(3), and on the facts of this case, section 31(3) was not complied with. Now, before the tribunal, you didn't take the objection
Because
section 31(3) was not being complied with. Why does that not fall within 73C?
it would fall.
Objection about a failure to comply with any provision of this part.
I think it would have fallen in the paragraph C if the tribunal had exercised its discretion under 31(3) improperly. But since it was not invited to exercise its discretion and make a determination on 31(3), there is no provision of that the tribunal did not comply with. They didn't do something, a provision that is directed at them, and having failed to.
Why does it have to be the tribunal?
Well,
Why can't it be the other? Suppose you're right so far that what C is concerned with is a failure. Why can't it be a failure of the other party?
Well, I think
That's how I
paragraph
actually
D.
read it.
I mean, paragraph D says any other irregularity affecting the tribunal of the proceedings. So it has to be a particularly serious kind of irregularity that affects the tribunal.
That's D.
That's D.
That is D. But I'm saying that was the answer to the question. The compliance with the provision has to be from the tribunal rather than the party.
Well, how do you get there? It's not an Easton Myanmaris reading.
Well-
It doesn't say by whom. There has been a failure to comply with the arbitration agreement. But with respect, the only person who can fail to comply with the arbitration agreement is the other party to it. The tribunal doesn't fail to comply with an arbitration agreement. They're not parties to that. So C's got to apply to the other party.
Well, the arbitration agreement may empower the tribunal to do certain things, but not others.
Yes, but the natural reading, if there's been a failure to comply with the arbitration agreement, you instantly look at the other parties of the arbitration agreement and say, have they or have they not failed to comply with it?
But I think 2 points on that. Our main case is that it should be read as I've suggested. But if we're wrong on that, and if it may be read as my lady suggests, then our submission is that the reading that comes out of section 73 becomes quite difficult for the provision to operate properly, because in a sense, The Czech Republic is saying that we were too late to object to their lateness, and so we now have lost the right to object to their lateness. It is not a point that they themselves raised promptly, so we could go on and on. So they did not raise promptly vis-a-vis us the fact that we were failing to do more of our new objection point and put to them the fact and put to us the fact that we should have actually raised an objection. So by their logic, if we were too late to object to their lateness, then they were also too late in failing to point out our alleged non-compliance with BCOD. And it just simply can't work. Where does it stop? And the clearer reading of this provision on our analysis that one has to remain focused on the party that has to object, not on the innocent party. It's the party that has to object. They have to do certain things at certain times. If the innocent party fails to raise a flag, well, that doesn't necessarily neutralize the objection, the failure of the main party to take the objection promptly.
Okay, right.
So that's our point about the difficulty with trying to use the waiver point under Section 73 against us. And by contrast, we say our reading of the provision does not encounter any such logical difficulty. I note that and I think it's a point that Mr. Goodman made, the Section 73 point against us wasn't even pleaded. So we would have the problem of deciding on their own lateness, which makes the whole thing really quite difficult to operate. My lord, my lady, now turning to the ancestral rules, I can do this briefly. This is Article 23 of the ancestral rules, which is at LA 56. And that's also in volume 8. And the
page 22.
Yes, page 22, yes. Tab 56, page 22. In an ancestral arbitration, we are not faced with many of the difficulties that might arise in the other arbitrations, because 23 is in some ways quite aligned with what 31 sets out. If they were not, then 31 would obviously have to prevail. Section 23 confers the general power on the tribunal to rule on its own jurisdiction. And then paragraph 2, rather, of Article 23 identifies the steps that the party that wants to object has to take. We don't see this provision as giving rise to any particular difficulty, because it can be read quite easily together with the interpretation that I've advanced of Section 31. The one authority to which I would like to take the court briefly is the Karen Kaplan commentary. This was relied upon by the Czech Republic. It's tab 56.1. It's not one of the printed authorities, I'm afraid. Tab 56.1, and if we can have page 7. I think this is simply to make the point, the first paragraph after Section 5, the Article 23, rather the second paragraph, articulates a broader rule with respect to the arbitral tribunal's powers to rule on its own jurisdiction, as opposed to ruling only on objections that it has no jurisdiction. So there was a change from the previous version to this version, and the new version is more aligned with Article 31. And at page 6, the third paragraph, this was a sentence on which the Czech Republic relied in its skeleton. The third paragraph, if a party fails to raise a plea as to the arbitral tribunal jurisdiction within the appropriate time limit, and the arbitral tribunal chooses not to consider the late plea, the party is generally precluded from raising the objection during the remainder of the arbitral proceedings. final sentence, which wasn't in the skeleton, in our view, is quite important because it says the extent to which the party may raise the objection in post-award proceedings, such as set-aside and enforcement, is determined by the applicable law. So even in the eyes of the ancestral rules, whether the party has lost or not the right to relitigate the point before the court in set-aside proceedings is a matter for the applicable rule, which in our case is section 73, interpreted as I respectfully suggested. But the two very simple points is that this rule also allows for the tribunal to determine its own jurisdiction, even if not prompted by an objection, and it specifies that the question of objections in post-award proceedings is one that is not answered by the rules, but has to be addressed by the applicable rules. If I may now turn to the judgment, which is at Core Bundle 12. There are two paragraphs where Mr. Justice Foxton sets out his analysis, and I would just like to take the court briefly to them. So we go to page 30, it's paragraphs 85 and 86 that I'm interested in. So he begins paragraph 85 saying, approach purely as a matter of principle, there is some force in the argument that if a party who needs an extension of time to advance an argument does not request it, with the result that the arbitral tribunal has not been asked to consider whether to give an extension and has not been required to do so, and the other party has not been called upon to address the question of extension, it is quite something to assume that an arbitral tribunal has granted an extension simply because it has proceeded to address the issue on the merits. And so far, we obviously agree with that articulation of the principle. It is indeed quite something to assume that an arbitral tribunal has granted an extension, or even more so, has admitted formally an objection on the basis of justified delay without any clear determination to that effect. So that the principle, it's interesting the judge refers to it as the matter of principle, we say falls on our side. The judge then concluded that the provision had to be interpreted differently in a way that doesn't favor our case because of a number of pragmatic considerations that he sets out at paragraph 86. And I would like to go through these pragmatic considerations in turn. Of course, one has to be a bit careful to just let a principled interpretation that, on our case, accords with the language and the scheme of the Act to be outweighed by pragmatic consideration. But nonetheless, with that in mind, I'd like to go through the reasons. So as for the first pragmatic reason, it's Roman letter 1, the judge considered that if the other party takes the point that it was made out of time for the first time before the court, it will be too late for the challenging party to seek an extension. But with respect, this pragmatic reason begs the question. It is premised on the idea that it is for the innocent party to try to take a step that make life easier for the party that is caught by section 73. And we also submit that in practical terms, it doesn't quite work very well, an alternative interpretation, because all that a party has to do to preserve its right subsequently is to proceed in a certain way. And if it doesn't do it, that right must be gone. We say this is more practical than allowing a situation where objections could be allowed in sub silentio or through the back door or in a number of other ways. There has to be clarity.
But you showed us that the DAC report was rather against people keeping points up their sleeve, but you say it's perfectly okay for your side to keep up their sleeve the point that this objection was raised too late, and that's what your current submission comes to.
Well, we deployed the point before the court, which was the right time to deploy it, because the determination.
No, you did. I mean, we don't know, but it could be. It could be that in the arbitration you thought to yourselves, they've taken this point too late, but we'll keep that up our sleeves.
Well, I mean, to look at really the facts of what happened, we made the point that it was new, and we were faced with the notion that it wasn't new at all. So if there is a straight denial of the fact that we are in this territory, I think it was perfectly legitimate for us to proceed a few weeks before a massive hearing on the basis that we were not going to concentrate on those 2 or 3 paragraphs in the rejoinder. And there wasn't any thinking of keeping points up the sleeve. It was just the way.
Well, I'm not concerned with whether on the facts of this case you were. I'm not suggesting that at all. But your submission is that it really doesn't matter, and the party can keep up their sleeve if they want to. The point that the objection has been raised too late.
I think it doesn't matter for all points. Obviously, there are certain points where those obligations would kick in, but for the reasons that I gave before on paragraphs B, C, and D, we're not caught by them, and if we were, that point wasn't put to us in a timely manner either. So it doesn't really, we say, answer the question of the operation of 73(1)A vis-a-vis the Czech Republic. But ultimately, the point that it is said we should have taken was a warning to the other side that they were at risk of losing the possibility of running this argument again before the supervisory court. And we simply say it's not a point for us to draw their attention to.
Okay.
The second pragmatic reason given by the judge as Roman letter 2 is that an arbitral tribunal should not have considered an objection undermines the general policy of minimum intervention by the court enshrined in section 1C. And I think I dealt with this concern in response to some questions. We don't take aim at the tribunal, we don't ask the court to intervene in the arbitral process. So we don't think that principle of the Arbitration Act is engaged. The judge then goes on to say at the end of paragraph 2, in considering the difficulties which might arise, it is helpful to consider the position where the arbitral tribunal upholds a jurisdictional challenge said to have been taken late. If the other party wishes to challenge that determination, not on the basis that it was wrong on its merits, but that the point was taken too late, it must bring itself within section 68. And let's consider this scenario. Let's assume that on this case, the determination on the merits had gone against us. If the tribunal had upheld the contested objection. I think in that case, we could have had a section 67 challenge to the determination on the merits. On our analysis of the Act, we couldn't have had a section 68 challenge because the tribunal upheld a jurisdictional point that was articulated late, but it did not admit the objection. So on our analysis of the Act, in that scenario, all we would have had is section 67, not section 68. If, however, the tribunal had admitted the point and made a determination of justified delay in terms without inviting us to make submissions, we could have perhaps pointed out that that was an irregularity in circumstances where the Czech Republic had not sought such an admission and in circumstances where we had not been given the chance to respond to it. But my answer to that difficulty is that actually it works well. If the point goes against us, we can challenge it on the merits, but we don't automatically have a 68 challenge. The third pragmatic reason is that the judge considered that where the respondent to the challenge is required to take the timing objection before the tribunal is able to consider not simply whether to grant an extension, but whether one is required. And I think our answer to that point, as I've already indicated, is that the question of lateness, as far as Section 73 is concerned, as we've also seen from the ancestral commentary, is really one for this stage of the proceedings. And it is not one to which necessarily the tribunal had to turn its attention. If it had to, it was for the Czech Republic to make sure that it did. It wasn't for us to make sure that it did, because they need the positive admission. We don't need a negative admission. They need the positive admission of a late objection and justified delay, but it's not something, it's not a hurdle that we need to clear, it's one they need to clear. The fourth pragmatic reason was a reference to the collaborative nature of the arbitral process, and this is where I refer to our, I think, analysis also, our submissions also on the Barton principles, and on the fact that that collaborative nature, even in an arbitral process, can be taken as far as a duty for any party to identify problems that the other party may be creating for itself in the future. A duty to warn. It simply can't go as far as that. We were under no such duty to warn, either impliedly or expressly. Our approach, we respectfully submit, is the one that practically works in a clearer way, because one knows what one has to look for to decide whether the right to object has been lost or not. What one has to look for is whether the objection has been made within the time limits in section 31. If it hasn't been made within the time limits in section 31, anything else the tribunal says on jurisdiction should not be assumed to have been responsive to an objection that was timelessly raised by the party. And the approach based on the judge's reasoning with respect is the one that we say leads to confusion, because there is a state of uncertainty as to whether something has been admitted or not, as to whether a right has been preserved or not, and the parties don't quite know what they need to do. And both of them can be affected by this confusion, because one party can't be sure if it has the right to rerun the point. The other party isn't sure whether it can raise that point later on. So there is a state of confusion that I think is created by a situation where we try to interpret the terms of the legislation in a way that allows for a flexibility that simply isn't there. My Lord, I was going to go briefly now through the three cases. There are three commercial court authorities on this point. I can go through them probably in 10 or 15 minutes. The first one is the Stockman case, which is the one that for some reason has given the name to this point. And that's at tab 45, which the court has at volume 7.
Is it called the Stockman point in arbitration writings generally, or is it just a label that's been used in this case?
It's certainly been used in this case, and I think, I don't know if Mustel and Moyd has now embraced that language. No. We may
it's just a label for this case.
It's just a label for this case, and we may be responsible for that label because it's obviously the case that favors us most. So the issue in this case was whether a further award made by an LCIA tribunal following remission from the court fell within the scope of that remission. And in particular, the question was whether in the remittal proceedings, the arbitrator had jurisdiction to consider a claim for damages in lieu of specific performance. The analysis of the section 73 point begins at page 28, which is paragraph 144. So what happened is that Stockman objected to the jurisdiction of the arbitrator to consider a claim for damages in lieu of compensation after the further award had been issued. And Aricano, the defendant, argued that the claimant should have made the jurisdiction objection when the claim had first been put forward, not at the remittal stage. And the deputy judge, Mr. Hanko KC, concluded that each case will turn on its own facts, but on the facts before him, there was no implicit extension of time by the arbitrator. And he lists the factors on which he placed reliance to justify his conclusion. First, these are paragraphs 150 onwards, it's on page 30. The claimant never made an application to the arbitrator to exercise his discretion to extend time. The arbitrator was therefore never asked to address the principles under Section 73 and Section 31.3, and it was not safe to assume that he would have extended time had he addressed those principles. Now, Stockman is not on all fours with our case, because our case goes further. We say implicit admission of an extension. We want us to be quite careful, if ever. The judge here was considering the case on the basis that there had to be coordination between 73.1 and 31.3, but there was also the use of the more general language in 73.1 rather than the more specific. But in essence, the approach taken by the judge is in accordance with the one we respectfully put forward. Another case which was the object of extensive submissions before the judge is the Serbian ImageSat case, that is at 41, tab 41, also volume 7. This was an ICC arbitration. The substantive question was whether Serbia was the successor state or the continuing state of the Union of Serbia and Montenegro. That was the issue. Because the Union of Serbia and Montenegro there had been a referendum in Montenegro at some point. Montenegro had seceded, and so Serbia was being sued, but the party to the contract had been the State Union of Serbia and Montenegro. And there's a difference in international law between being a successor state and a continuing state. But to understand how Section 73 was applied to this objection, I think it is useful to just briefly go through the facts of this arbitration. If we start from page 10, paragraph 38, we see that the request for arbitration was sent on the 8th of June 2006. Paragraph 43, the answer to the request, this would have come from Serbia, came 3 months later in September 2006. Under the applicable rules, the answer to the request was the first step in the proceedings in terms of Section 31. So Serbia had to raise its objections by the time of the answer to the request, not the counter memorial as we have in the Anstral case, because these are arbitral rules, like a number of them, that require a substantive answer to a request for arbitration. Serbia did not raise that objection in its answer to the request for arbitration. It raised it later, and the terms of reference were agreed in this case as well. Paragraphs 46 and 47 of the judgment discuss the terms of reference, where Serbia had agreed that it was not aware of any objection to the jurisdiction, and Serbia also agreed that it was a successor to the State Union of Serbia and Montenegro, the successor, not the continuing state. So this had happened in the first year or so, and then, paragraph 54, Serbia raises its objection in the statement on defense filed in May 2007 that it was not the successor state to Serbia and Montenegro. So its objection was clearly late under Section 31.1. At this point, and this is quite an important passage to understand why the judge reaches the conclusion, Mr. Justice Beatson, that he reaches, ImageSat, the other part at this point, does two things. First, paragraph 55, ImageSat asks the arbitrator to bifurcate on this very preliminary question. And it invites the tribunal to determine a preliminary question that is put in the terms that the court can see at paragraph 55. So that was all ImageSat's initiative. ImageSat receives this late objection, it writes to the tribunal, and it says, bifurcate on this point, and this is the issue that we want you, tribunal, to determine. The other thing that ImageSat does, a bit later on, paragraph 58, is that it changes its own position. So ImageSat says that Serbia was the continuing state, not the successor state, but the continuing state of Serbia and Montenegro. Serbia then says, you can't change position now, it's too late. you started this arbitration on the basis that we were the successor state. We are now saying we're not the successor state. It's too late for you to change position. So in effect, the judge was dealing with two competing waiver arguments. Serbia was saying Imetsat is subject to common law waiver. It can't raise this point against us anymore. And Imetsat was saying Serbia is subject to 73. It can't raise a jurisdictional objection this late. So really quite a unique set of circumstances in this case. The judge found against on the waiver points, respectively, Serbia and Imetsat point, and decided the objection on the merits. What had happened is that basically neither party had appreciated that Serbia, as a matter of correct analysis, was obviously the continuing state and not the successor state. It's a point that had not occurred to them. And so they both made a mistake and they were trying to run things too late. And the judge, in a sense, equalized the position and said and made a determination. It is against this background that Mr. Justice Beatson reaches the conclusion that he reaches. We say this case is clearly distinguishable from our case for two reasons. First, we never invited the tribunal as expressly and as specifically as Imetsat has done to determine this point as a discrete jurisdictional objection. We didn't seek bifurcation of the Karuna control objection point. We didn't put the issue specifically to the tribunal and say, please determine it. That must be an important difference. And second...
How's that a difference that affects any of the legal arguments you've been addressing?
Well, that's a very fair point. And I go back to my pure analysis. On my pure analysis, even this case was wrong. Because even in this case, there had to be a proper admission. But I do understand the difficulties that your lordship has been putting to me in terms of scenarios at the margin. And all that I'm saying is that this case might be one of those cases at the margin where we could be thinking of an implicit admission of some kind, where a party specifically tells the tribunal, please determine this point, let's have a hearing just on this point, let's go through the process of exchanging skeleton arguments, discuss only this point, and then later on says, oh, it was too late. It is quite different from here, but I accept that on my principal case, even this wouldn't be good enough. I think that's our submission on this case. And I note at paragraph 109 that Mr. Justice Beatson also, interestingly, used the language that Mr. Justice Foxton later uses, the right in principle. That the approach that essentially we are putting forward is right in principle. So the reaction of both judges is at first to say it is right in principle. We say Mr. Justice Beatson was confronted with really quite a unique set of circumstances, but and decided the point as he did. Now the last case, one with very eminent counsel, is the Gulf import, and I don't know if it's Bungie or Bungie or Bunge, but it's only the other.
People say Bungie.
Bungie, okay. It's the third case where this point came up. It's LA 40. And of the two cases, it is probably the least relevant because the issue as to the lateness of the claimant's jurisdictional objection was found to be academic, and we have that at paragraph 48, page 17.
It's referred to in the other two cases, isn't it?
Apologies, my lady.
I said it's referred to in the other two cases.
Yes, it is referred to in the other two cases. Yes, but here, so the obiter commented that paragraph 47 is the one that is referred to in the other.
Relied on by Mr. Justice Beatson, certainly in his case.
Yes, and what is relied upon is that middle part of paragraph 47, where it is said that it would have been bizarre for Gulf to be precluded from running the point in the court, given that Bungie argued the point that the board decided it. And it seemed that by allowing the point to be argued either the board had exercised its discretionary power to extend time, or the objection had been taken within the time allowed by the tribunal. Now, our response to this case, I think I've probably already set it out in my submissions. This paragraph, although as Lady Justice Andrews rightly points out, has been referred to in the subsequent decisions, doesn't quite grapple with the question of how the board could have exercised its power under Section 31(3) to extend time if it was not asked to do so. As to the comment that it would be bizarre if the party that raised the objection were to be worse off, I think I've dealt with that in response to the points made by Mr. Justice Foxton in his judgment in paragraph 86 on the pragmatic consideration. Yes, Gulf would have been worse off, but that is precisely the point of Section 73. It makes the party that doesn't comply with certain steps worse off. And on the assumption that Gulf's objection was late, which I think on the facts of this case was disputed, but on the assumption that the objection was a late objection, then it would have been for Gulf to take the necessary step to preserve its right to object later. And if it did not take those steps, the sanction must apply. So
that seems to me to be the very argument that Mr. Owen submitted in Republic of Serbia, which was rejected by Mr. Justice Beatson.
Yes, and as I said, my lady, I think which is where Mr. Justice Beatson relies on this principle. My answer to the Serbia case is, as I said, that yes, it is against us on our principal case, but it is also quite remarkable that the facts were really quite different, and particularly the fact of the party inviting the tribunal to determine that very issue with a request for bifurcation, that is a very material difference. Insofar as one is prepared to read the words allowing or admitting as including some implicit admissions that by reference to the conduct of the party, that's the sort of case where perhaps one might reach that conclusion. But it's quite a high bar.
On your analysis, it doesn't matter that the party asked. It doesn't matter what the innocent party, as you put it, asked the tribunal to do, because it's not for the innocent party to do anything. It's for the other party raising the objection to ask for the extension of time. So I can't at the moment see how you can distinguish it on the basis that the innocent party asks the tribunal to deal with it.
I apologise. Perhaps I wasn't clear. On our principal case, I don't need to distinguish it because it's a case that is against us, and our principal analysis is different from the analysis of Mr. Justice Beatson. On an alternative case, one where there is some room for flexibility in the words allowing, admitting, then that factor might become relevant.
I see.
So it's only on our alternative case. Apologies if I wasn't
I
clear.
understand. Thank you.
So that's what we say on the three cases. And my lords, my lady, that only leaves the waiver estoppel point. And I'll turn in a second to the team if there's anything else. I can be quite brief on that point. That's a point that has been taken against us. That says, in effect, the Czech Republic says if we don't have the statutory waiver against you, in other words, if they can't rely on paragraphs B, C, or D against us, then there is a common law waiver estoppel point. We have said in response that this case is not open to the claimant because it wasn't pleaded and depends on factual evidence, for example, as to reliance. Mr. Goodman took the court earlier to the passage in the post-hearing brief where the Czech Republic insisted the point wasn't new, so it'd be difficult to demonstrate reliance on what we allegedly may have induced them to rely on if they simply thought the point wasn't new, and that's the position they took consistently. And we say this argument also fails in circumstances in which a party is entitled under the Act to rely on the opponent's failure to seek the tribunal's permission to raise a late objection. I think the attempt to ground this argument in Article 32 of the Ancestral Rules, perhaps we can go there briefly, also fails. This is LA 56, page 27. The waiver provision in Article 32 cannot extend beyond the arbitral proceedings. Or put differently, where Article 32 provides that a party can lose the right to make an objection, it is referring to the right to make an objection to the tribunal. It can't refer to any rights that a party has in the set-aside proceedings. And this is clear from the language of 32. And I also note that Article 32 of the Ancestral Rules refers to a failure by any party to object promptly to any non-compliance with these rules. We're not here looking at an alleged non-compliance with the rules. If, contrary to our main case, that 32 doesn't go to these proceedings, the court were to conclude that the effects of Article 32 extend beyond the arbitral proceedings, then insofar as the Ancestral Rule purports to create a different regime to the combined effect of 31 and 73, that would amount to an impermissible modification of a mandatory provision of the Act. So it simply can't. We don't think it can be read in that way, Article 32, but insofar as it is being read in that way, it is not a permissible reading for an arbitration seated in this jurisdiction. I will listen to what the other side has to say on waiver and estoppel. For the time being, I wasn't proposing to say anything else on this particular point. And so, my lords, my lady, that, I think, can I just check with
Yes, of course.
Yes. At the beginning, I made the point on the timeliness comment of the tribunal, and I said if that comment at paragraph 310 of the award is important, one really needs to understand what it is referring to. And the point that I was making, if it wasn't clear, was that it cannot apply to the objection that Mr. Stava did not hold investments. And that is because, as I showed by taking the court through those paragraphs, that very thin discussion of lateness are saying it is new, and the tribunal's comment were by reference to the investor objection. So it couldn't go to the Stava objection, because Stava, to be an investor, all he needs to be is Swiss. And the Swiss nationality point is not open for argument again. That's a closed argument. He's an investor, Stava. So insofar as there was a sense of newness that we tried to convey in our rejoinder, and that the tribunal picked on, it was newness of the investor point, but it can't be about the Stava June 2011 point, the standing point. And that also explains why the tribunal in the award has that at the very end of that section on objection 5. I'm happy to go back to the award if it helps, just if the point isn't clear, or I can come back to it in reply.
I'm afraid I'm not quite following.
So if we go to the award at paragraph 310, so that's SB 23. And it's page 101. So we are trying to understand what the tribunal may have done, assuming it could do anything, which is not our case, by noting to which they do not raise timeliness objection. So that is the issue. What does this comment go to? And our position is that this comment can only go to the investor objection because it appears in the section entitled, page 100, objection number 5, claimants can be deemed investors of the other contracting party. It can only go to the objection of whether Mr. Stava or Diaghuman were investors under the treaty.
How could the question of whether he'd relinquished control have anything to do with whether he was an investor? Because, as you say, it's all to do with his nationality as a Swiss person.
What it doesn't. That is my point. It doesn't. It can't capture anything to do with Mr. Stava.
The point against you is the objection was obviously not whether or not he was Swiss. He was Swiss. The investor objection was whether he was an investor in relation to the investment, as required by Article 2, or I'm going to be told some other article.
No, well, I mean that's a point that we will develop when we get to the next objections.
What do you say? The investor objection to Mr. Stava was.
The only investor objection to Mr. Stava was his nationality. There was no other investor objection to Mr. Stava. An objection to Mr. Stava on standing was a separate objection. And when the tribunal analyzes the objections, if we go to page 122, we have objection number 5, whether claimants can be deemed investors of the other contracting party. The tribunal deals with this objection at page 122, 123, 24, 25. And if we start from, actually, apologies for going back, but if we start from paragraph 397, this is objection 5. Paragraph 397, Mr. Stava became a Swiss national. They're dealing with the investor point against Mr. Stava at paragraph 397. Paragraph 398, they're now moving on to the investor point against Diaghuman, and they're dealing with that at paragraph 398. From there onwards, it's all Diaghuman, and then if we turn to page 126, paragraph 413, objection number 5 is dismissed. That is the end of objection number 5. The next point at paragraph 414 is the standing point. And that's a separate point on the way in which the tribunal understood these objections to operate. So that timeliness comment, insofar as there is any against our main case, if there is any implied admission of a late objection, it could have only been the late objection or to investor. So concerning Diaghuman but not Stava.
There's a cross-reference to a rejoinder on jurisdiction. Have you shown us that before?
Yes, I think it's one of the paragraphs.
Could you possibly please remind us?
Yes, it's supplementary bundle, tab 19, page 27. And
it's a new objection which is somewhat obtuse.
And
it's all to do with timing. That's nothing to do with status as a Swiss national, is it?
Well, what we said here, the heading is the claimants are both investors within the meaning of the BIT. And as far as Mr. Stava is concerned, it has to be his nationality. And the standing objection, in the way in which the tribunal deals with
it could be the connection between his status as an investor and the investment, which is what.
Well, that seems to be what 65.
That's what 64 seems to be.
the
new objection, although it's characterised as appearing to be somewhat obtuse, by reference to whether either of the claimants can bring a claim in respect of conduct after June 2011. That's obviously a reference, isn't it, to a change of status in June 2011.
Well, it is a reference to the no investor objection, and it could have only affected Mr. Stava if somehow it had affected his nationality, which couldn't have been the case. So
one of the objections we've got to address in the other appeal is whether Mr. Stava's claim is affected Mr. Starver's claim is affected
Yes.
by his relationship to DIAG from June 2011 onwards.
Well, our point on that is simply that insofar as the parties and the tribunal were thinking of dealing with something, well, rather us, and the tribunal were thinking of dealing with something new, it was in the investor objection space, which doesn't extend to Mr. Starver. But of course, I appreciate that the language may not be entirely clear. But the fact that the tribunal itself separates it in that way and deals with standing as a separate point at the very end of that section confirms in our submission this analysis. But these are points to which we may return in the course of the other two objections.
All right. I mean, certainly from paragraph 64 of your rejoinder on jurisdiction, it's very clear that your understanding, or your side's understanding of the new objection, was that it related to both of the claimants. That's crystal clear from paragraph 64. You may have been wrong about that on analysis, I suppose, but that's what you said. Okay.
Yes. Now, I think that the point is the tribunal's timeliness comment to which of those objections, because those paragraphs in the Czech Republic's rejoinder have developed into quite a number of different objections. So we are trying to extrapolate all of that from those three paragraphs. And in our analysis, the tribunal would have understood timeliness, its comment on timeliness was by reference to the investor point. So that paragraph 310, if it has any weight at all, contrary to our main case, is about the investor point.
Right.
So unless there's anything else, my lord, that's the end of our opening submissions on this point.
Thank you very much. We'll rise for a few moments. We don't need to trouble you, Mr. Bastin. We'll move straight to the next two appeals.
My lord, my lady, I benefit with gratitude from the submissions of Mr. Goodman this morning in terms of situating this appeal and indeed the control appeal including by reference to relevant paragraphs in the award and in the judgment below. So in those circumstances, I'm going to move immediately into the substance of the appeal. My lords, my lady, the objection that the tribunal had no jurisdiction to consider claims by Mr. Stava after June 2011 because he had disposed of the assets said to be investments is in our submission an objection to substantive jurisdiction. There are two sources that will essentially help the court determine this point. The first and foremost is the terms of the treaty. And we also submit that previous decisions will give some guidance in elucidating the relevant principles. The bulk of my submissions will be structured by reference to each of those sources. And I will start with the terms of the treaty. Now, this court may well know how bilateral investment treaties are typically structured, but I do wish to take some time to turn through the particular terms of this treaty. As has already been adverted to by the court, the terms of this treaty, including, as your lordship, Lord Justice Popplewell has mentioned, Article 2.1, are important to the determination of the point on this appeal about whether the objective is one of substantive jurisdiction.
Well, although, speaking for myself anyway, I have some understanding, but these investment treaty cases don't come before the courts as often as some other arbitration disputes, so I'm quite willing to be educated about how they work.
I'm grateful, my lord. In that case, I hope we can then all enjoy SB 22 appearing on the screen. I did have hard copy bundle references for the previous appeal read for me, but you may need to bear with me because I was not planning to take the court to references the hard copy bundles on this appeal. Now, supplementary bundle tab 22, one finds the bilateral investment treaty that applies in this case. If we could start on page 1, please, operator. We see that the front page is a preamble. This page is a very common type of starting point for this type of treaty. And it's important, my lords, my lady, because it assists the court in establishing the object and purpose of a treaty and also forms context in which its terms are interpreted. I use those phrases of object and purpose and context because they are important in the rule of interpretation found in Article 31, paragraph 1 of the Vienna Convention on the Law of Treaties. As one can see in the third preambular paragraph on the screen, one of the objects and purposes and part of the context in this treaty is that it is intending to create and maintain favourable conditions for investments by investors of one contracting party in the territory of the other contracting party. Just to pause on that. The language of by investors is brief, but it is significant. Indeed, as the court may or may not be aware, the significance of that language has attracted wide attention in investment arbitration jurisprudence. That language stresses the point that the court has already mentioned in the previous appeal earlier today, that the treaty is there to protect investments by investors, not just any asset held by someone in the relevant jurisdiction. Now, we will see more of this language as we go throughout the BIT. Indeed, this is a point which is familiar to the English courts because it's precisely the type of point that was discussed by Mr. Justice Butcher in Tatneft, with which the court may well be familiar. Can we please go over the page, operator, where we see Article 1. It is very common in these types of treaties, my lords, my lady, for the first article to define the terms investor and investment. Indeed, the language that we see in this Article 1 is relatively familiar language that one sees in some treaties concluded in the same part of the world in roughly this period of time that this treaty was concluded. And this is always an important provision in a treaty because of how it delineates the scope of both the substantive provisions in the BIT and the offer to arbitrate in the BIT. We'll come on to those substantive provisions and the arbitration offer in a moment. But I do want to pause on Article 2 of this treaty before we turn there. If we scroll down to the bottom of the page, somewhat unhelpfully, the title Article 2 and scope of application appears at the bottom of the page. And then the text of the provision is on page 3, please, operator. There one can see at the top of the page the text that delineates the scope of application of this treaty, including with reference to the defined terms in Article 1. I am just going to take a moment to read through Article 2.1. The present agreement shall apply to investments in the territory of one contracting party by investors of the other contracting party if the investments have been made later than 1st January 1950 in accordance with the laws and regulations of the former contracting party. So in the same way that we saw this foreshadowed in the preamble, this provision is clear that this treaty can only apply to investments by investors of the other contracting party. And then if one looks at subparagraph 2 of the article, it adds a further point. The present agreement shall not affect the rights and obligations of the contracting parties with respect to investments that are not within the scope of the agreement. So in addition to the point of by investors in paragraph 1, it is also a delineating feature of this treaty that the treaty shall not affect the rights and obligations of the Czech Republic with respect to investments not within the scope of the agreement. That may in some ways be seen as the corollary of the first paragraph, but it's an important corollary. It is making entirely clear in my submission that if there is not an investment by an investor in the context of a particular arbitration, then that falls outside the jurisdiction of the treaty, outside its scope of application, according to paragraph 1. And the host state, here the Czech Republic, will have no obligations under the treaty in relation to that investment. Now, I do suggest, as your Lordship, Lord Justice Popplewell has adverted to a number of times today, that this is an important provision in the treaty. It's not the only provision that we rely on. I'll be going to the others in a moment. But this type of provision states in explicit terms the scope of application of the treaty and thus delineates the jurisdiction of the tribunal. A tribunal constituted under Article 9 of this treaty only has jurisdiction within the defined scope of application of the treaty. Now, taking my guidance from your Lordship, Lord Justice Mayles, it is correct that in investment treaty practice, not all treaties have a provision like Article 2. Indeed, there are plenty of treaties that have no scope provision at all, and those that do will draft that provision, will agree that provision in the particular terms that the contracting parties to that treaty wish to agree. But what one ought not to do is regard Article 2.1 and 2.2 as a run-of-the-mill provision that is simply copy-pasted from one treaty to another. It is not, and in my submission that highlights its importance. It is a provision, frankly, that bothers to set out the scope of application of the treaty and thus the jurisdiction of the tribunal in a way that other treaties do not. And as a result of that provision, my lords, my lady, the entirety of this treaty, its substantive clauses and its arbitration clause, only operate within the limitations articulated by Article 2. Now that, of course, is a point of interpretation. The treaty has no existence outside what is stated in Article 2. As this court will know, a good faith interpretation is required by Article 31, paragraph 1 of the Vienna Convention. And indeed, a good faith performance by the contracting parties to a treaty is required by Article 26 of the Vienna Convention. And that means, in my submission, that this treaty has no scope absent an investment by an investor. A good faith interpretation reaches that conclusion, and a good faith performance of this treaty only requires the protections that it affords to be extended to an investment by an investor, consistent with the scope in Article 2. Absent those features, the tribunal constituted under Article 9 has no jurisdiction. Absent an investment by an investor, that is a jurisdictional limit. Now, in my submission, Article 2 weighs very strongly in favour of the Czech Republic's position in this appeal. It does set the jurisdictional limits under the treaty, and clearly says that one of those limits is that there must be an investment by an investor. And this connection, this important connection that runs deep in investment treaty arbitration practice, unsurprisingly permeates the BIT. I come now to the other provisions in the treaty that I have foreshadowed. I start with the substantive protections. The first is Article 3, which is on the screen in page 3 of the document. One sees there that the provision begins, each contracting party shall in its territory promote investments by investors of the other contracting party. Article 4, paragraph 1, a little bit further down, a very similar drumbeat of language. Each contracting party shall protect within its territory investments made in accordance with its laws and regulations by investors of the other contracting party. And then goes on to articulate a further protection in the same sentence, and shall not impair by unreasonable or discriminatory measures the management, maintenance, use, enjoyment, extension, sale, and liquidation of such investments, i.e., investments by investors. Paragraph 2 of Article 4 contains the very well-known fair and equitable treatment protection. And again, one sees the use of language that is echoing what we've seen in the preamble, in the scope of application provision, and in the other substantive provisions. Each contracting party shall ensure fair and equitable treatment within its territory of the investments of the investors of the other contracting party.
So surely, if the arbitral tribunal is faced with a dispute, somebody claiming that there's no fair and equitable treatment, and there's a dispute as to whether it's an investment or an investor, the tribunal has to decide whether or not they are people to whom the obligation of fair and equitable treatment apply.
Indeed, my lady.
And that's a matter of substance and not of jurisdiction.
With respect, my lady, in the context of investment treaties, that is not correct. And the reason it is not correct is that the concepts of investor and investment do not have their only life in the substantive provisions of the treaty. Indeed, to the contrary, they are given their life and their scope is defined in Article 1 of the treaty. And when those terms, investor and investment, are defined there, they're then used, I certainly accept, throughout the substantive provisions, but then are also used to define the scope of the consent to arbitrate. In my submission, that is a jurisdictional, not a merits delineation, according to the terms of the treaty.
There is no doubt, is there, that before 2011, both Mr. Stava and Diaghuman were investors who had made an investment.
In the context of this appeal, my lord, yes.
Yeah, I mean, it may have been disputed before, but all those points have been closed off now, and that's where we are.
Yes, and the only reason I say in the context of appeals that my learned friend Lord Verderama has already done good work explaining what points were taken below, when PTA was given, and also what points were taken in the arbitration. So for present purposes, the short answer is yes.
Yes, right.
I will just continue through the substantive provisions before I then come to the offer to arbitrate, because I suspect that provision will engage with my Lady Justice Andrews' question in further detail.
Just before you do that, conceptually, when someone becomes a qualifying investor in a qualifying investment, is that the point of time at which there are vested in them the rights to protection which the treaty confers? They have those rights from that point onwards.
Yes. And to take the example that we are working with here about the very simple investor objection, there are naturally plenty of people with Swiss passports. And so if we go back, please, operator, to Article 1 on page 2 of this document, one can see in paragraph 1A that if there is a natural person who is a national of a contracting party in accordance with its laws, so in the context of Switzerland, that would often be said to be when an individual holds a Swiss passport, although I note that that is an open point in dispute between the parties, but it's closed off only for the purpose of this appeal, then that person may well be able to say, I am a Swiss investor according to the definition in 1A. But it's of course nonsensical to suggest that every Swiss individual is somehow relevant to or currently protected by this treaty, even if they hold no assets in the Czech Republic and have never even been there. What is required, as my Lord Justice Popwell indicates, is that there must be an investment of, to use the language of the treaty, that investor. And so it is only at that time that there is a jurisdictionally relevant connection between investment and investor,
so you
which gives coverage under the treaty.
That the person becomes an investor for the purposes of this treaty at the moment that they hold an investment as defined by subsection 2.
So if they are an investor with an investment or an investment by an investor,
yes,
that would be the moment when at least that part of jurisdiction is satisfied, my lady. But of course, there are numerous other aspects to the jurisdiction that a tribunal exercises, numerous other limitations in relation to jurisdiction. So I can't answer your question, my lady, with an unqualified yes, because that is not the complete step towards establishing jurisdiction under this treaty which the tribunal can exercise. If I can give a rather simple example to that somewhat abstract point, there also needs to be temporal jurisdiction, sometimes in the cases referred in highfalutin terms as jurisdiction ratione temporis. And there also needs to be compliance with any requirements that are contained in the consent to arbitrate, sometimes referred to as jurisdiction ratione voluntatis. So while the answer to your question, my lady, is it is a necessary part of establishing jurisdiction, that by itself is not sufficient. I will clarify one point, or extend my answer to your Lordship, Lord Justice Popplewell, just slightly. That even though, in answer to your question, an individual can become an investor with an investment, and there therefore is an investment by an investor in the terms of the treaty, they can also lose those rights or lose that status. That's, of course, an important point to bear in mind in the context of the facts of this case. While I'm answering questions from the court at the moment to a degree at the level of principle, I wouldn't want it to be confused in my answer to your Lordship that once one passes through that gate,
I understand that. But
I'm grateful.
I'm interested in when someone who is undoubtedly at a point of time an investor in an investment,
yes,
in when they acquire the rights to protection under the treaty, and I think you've confirmed
in that case,
that's when they first acquire them. You would say they could lose them, but that's when they acquire the rights to protection under the treaty, for so long as they remain a qualifying investor in that investment.
With an investment by that investor, yes. In that case, I think our exchange before answered the question entirely, but given the circumstances of this case, one can appreciate why one bookend should come with the other bookend hand in hand. Operator, could we please go back to page 3? I am going to take a little bit of time to walk through the rest of the treaty. And just by way of passing observation, what one sees on page 3 is sometimes referred to as the mistreatment protections. So these are substantive protections which a qualifying investor will have against mistreatment by the host state. When one goes over the page, one then encounters Article 5, which is again a form of mistreatment protection. One can see in the first line the same language of by investors, permeating, to use my word from earlier, throughout the treaty. And then in Article 6, the treaty moves into a slightly different type of protection. What is
there something missing in 5? The free transfer of the ... relating to?
So, my lord, one other feature of investment treaty practice, which is among its most unattractive, is that the treaties are often negotiated and signed in an original language, and one can well imagine that the Czech officials and Swiss officials did not sit down, discuss and debate the treaty in English, but then when they are converted over to English versions, which are still equally authentic, there can sometimes be a ... for a missing word. I can check exactly what that might be, but I think it might be returns is likely to be the word, or perhaps fund. Is it returns? We're not entirely sure, but it's likely to be the relevant noun identifying what is protected, whether it's returns or funds.
Okay, well, the precise word probably doesn't matter very much, but I think I get
For the sake of this appeal, no, but
since we are construing the treaty, just walk me through again the exercise we're doing. It comes into form in a Swiss version, a Czech version, and then there's an English version which is treated as authentic for the purposes of the Vienna Convention. Is that what
yes is the short answer, my lord. And the languages, I'm grateful, the languages are actually in triplicate. Operator, if we can go to page 8 in the treaty, the answer is recorded there. My lord, you can see that it is in that bottom paragraph, done at Bern on October 5, 1990, in 2 originals, in 2 wet ink signed copies, in German, Czech and English, each text being equally authentic. In case of divergency, the English text shall prevail. So I'm afraid, my lord, Lord Justice Nails, sometimes in these treaties one can see ellipses of the kind that you identified in Article 5. That is legally irrelevant when it comes to the principles of interpretation in accordance with the Vienna Convention. And indeed here we are fortunate perhaps that there is no ellipsis in a provision that is materially relevant to this appeal. Operator, could we please go back to Article 6, which I think from memory is on page 4. In Article 6, there is a slight gear change in the treaty, in the sense that it moves from the mistreatment protections to what is sometimes called a taking protection. I'll just leave the court to read in particular paragraph 1. That is the protection against expropriation, or as this treaty calls it, dispossession. Again, the language of investments of investors is in this core protection provision.
Would I be right in assuming that typically, in an expropriation case, someone who was formerly a qualifying investor in the investment will cease to be a qualifying investor in the investment?
Your Lordship has in mind, I suspect, if I can infer from a previous communication, the Daimler line of authority. And I accept that where the impugned conduct of the state takes place during the ownership period by the relevant investor, then there is a line of authority, of which Daimler is perhaps the best known, which says that that investor can still bring a claim sometime in the future after they have been formally dispossessed of the asset. I will, however, my lord, come to what I suggest is the more apposite, more recent, and more persuasive line of authority, which says that if at the date of commencement of the arbitration, the investor does not have the investment, there is no investment of the investor, then there is no jurisdiction. Your Lordship may well have seen those cases referred to in my skeleton, and perhaps the most recent and well-known is that of Alcor, in which Judge Christopher Greenwood was the presiding arbitrator. In those cases, the position is that if there is no investment by an investor at the date of commencement of the arbitration, then there is no jurisdiction in that case.
Are any of those cases, sorry, are any of those cases ones of dispossession?
Any of dispossession, my lady, if you don't mind, I will need to check that. I would.
I'd be very surprised if they were. It's the idea that one of the contracting parties can expropriate somebody else's property, and there is specific protection against that under the treaty, and they can then turn around and say, oh, arbitrators, you have no jurisdiction to deal with our bad conduct in expropriating your property because you're no longer an investor. It doesn't really seem a very attractive proposition.
So, my lady, I will need to check if any of the cases that are referred to on the date of commencement point address that exact situation. But what your ladyship's question with respect highlights is that one can see different categories of dispute where the time of the impugned breach and the time of the ownership of the investment will need to overlap in order to create jurisdiction. So if it is the case that, as in Daimler, the ownership of the investment is during a period of time when the investor is covered by the treaty, then that may well be a principled basis on which to say the tribunal will have jurisdiction to hear that dispute, even though the investor has been formally dispossessed of its investment.
We'll come to Article 9, but that can only be on the basis, can't it, that you construe Article 9 as being an offer to someone who is no longer an investor at the time of the commencement of the arbitration.
In those circumstances, it would be an offer, my lord, I respectfully submit, in relation to an investor who has held an investment.
A former investor.
And so that's why in cases like Mondev, on which my learned friends rely, the treaty language is very important. I'm taking this somewhat out of turn, as you can appreciate, but in Mondev, a case that is now 23 years old, the tribunal looked closely at the language of the relevant treaty. That treaty was NAFTA, the North American Free Trade Agreement. And as is recorded, and indeed emphasised in the award in Mondev, that treaty covered the situation where an investor makes or has made, past tense, an investment. And it's on the basis of that language that the Mondev Tribunal concluded that it had jurisdiction under the NAFTA.
That may be so, but if we were dealing with an expropriation case under this treaty, if one is to give effect to the protection in Article 6 by giving an investor, a qualifying investor at that time, a right to arbitrate to pursue his rights, then that can only be granted on the basis that the wording of Article 9 in this treaty applies to a former investor.
I would accept that, my lord, but that is also a point with respect that I'm not going to concede in the context of this appeal for two reasons. The first is that it is not relevant. This court does not need to make a finding that Article 9 extends to an expropriation breach in circumstances where the investor has been dispossessed. The only type of breach that has been found in this award is a mistreatment breach under the fair and equal treatment provision.
So investor may mean different things depending on the breach in the arbitration clause. Is that what you're saying?
Well, no, an investment, my lord, won't mean different things in the sense of having a different defined meaning under the treaty applying the Vienna Convention rules. But it is certainly correct that an investment will have different types of coverage depending on the substantive provision that is an issue and also the time at which it is an investment by an investor.
I follow that, but if under Article 9, investor means investor at the relevant time rather than investor now for the purposes of a dispossession claim, it must mean that for every other kind of protected activity, mustn't it?
With respect, my lord, no. And that is precisely why the structure of this treaty and my opening by taking the court through the treaty is important. Because if one has an investment by an investor, as those terms are defined in Article 1, then one needs to trace that through to the relevant substantive protection and then trace that through to the consent to arbitrate. Now, in that process, the jurisdictional scope that the tribunal can exercise may well shift. If, for example, there is both a mistreatment and an expropriation, then the jurisdictional scope that the tribunal can exercise under Article 9 will expand to cover both of those situations.
Why would it expand to cover both? I thought you were about to say it applies to one and not the other. Because that would logically fit with your analysis, but if it expands to cover both, I'm confused.
So, my lady, you're quite right. I'm taking this on the basis that my Lord Justice Popplewell was putting to me.
Right.
Certainly, the Czech Republic's position would be that there are alternative lines of case law that would allow a host state to say, if both those types of substantive protections are invoked in an arbitration, then the host state can make different types of jurisdictional submissions in relation to each of those substantive positions. Indeed, the debate that we have been having about Daimler and Mondev versus Alcor is exactly that type of situation. But the second reason why I suggested to my Lord Justice Popplewell that I do not need to reach a position on this, I do not need to concede the point, and the court need not make a finding on it, is that ultimately, in all of these situations, the proper characterization of the issue is one of jurisdiction. So while these types of discussions are frequently had in the context of jurisdiction debates for investment treaties, in my submission, where the court ultimately lands on that point may provide some elucidation, but doesn't alter the final position that determines this appeal, that the objection is a jurisdictional one. So that was the second reason that I adverted to before, my lord, as to why ultimately those points are not necessary for me to concede or indeed for the court to make a finding on.
I'm sure you'll develop your second point, but at the moment I don't see why it should be so. If you have somebody who is an investor, i.e. he's a national of the right country or he's incorporated in the right country, and he makes an investment, then he comes, or his company comes, within the scope of the treaty in Article 2. If the offer to arbitrate in Article 9 is an offer made to an investor who makes an investment to arbitrate disputes with respect to an investment, then a claim that he has not been fairly and equitably treated under Article 4 is a dispute with respect to investments, to which the defence may be, well, you sold your investment when we did the terrible things about which you're complaining. But I don't see why that shouldn't be a defence on the merits, as distinct from a defence going to jurisdiction. So in the course of your submissions, that's something I would welcome help on.
I'm very grateful for that indication, my lord. And I would go beyond gratitude and embrace that particular situation that your lordship has outlined. And the reason I embrace it is that what your lordship has articulated is a situation that we do see in the investment arbitration jurisprudence. Indeed, as your lordship has suggested, I will be coming to those cases. The two leading cases that consider the situation that your lordship described, which is of course the situation of this case, including the disputed point about the timing after 2011, has been considered by the tribunals in Phoenix and Czech Republic and Vöcklinghaus and Czech Republic. Those are cases that I am going to come to in a moment once I turn to the jurisprudence. However, I did wish to finish moving through the treaty in the first instance so that the complete package of the terms before the court in that instrument can be seen.
Well, you do that, but while I'm putting some of my cards on the table, as it were, let me also say that we're focusing in the second appeal on the position of Mr. Stava, who, on your case, disposed of his interest in Diacumen in 2011. But I don't see why. I mean, if you're right about that, you're right, and if you're wrong, you're wrong. But I don't see why the position of Diacumen would be different. It seems to me that the judge's decision on jurisdiction versus something else, whether called admissibility or merits or whatever, shouldn't be the same for both, so that the position of Mr. Stava and Diacumen would stand or fall on the same reasoning. So again, that's another point which I would welcome help on in due course.
I'm grateful, my lord. I will address that point over the course of my submissions, but can I briefly make these observations? Part of the reason why two claimants or multiple claimants in investment arbitration can have a different jurisdictional position is because each of them has different types of assets. Mr. Stava, of course, is not signatory to the cooperation agreements that were signed with the local medical facilities in the Czech Republic. Mr. Stava was not party to the arbitration agreement in relation to the underlying commercial arbitration. His interest, when he had it, was his shareholding in the second claimant, Diacumen. By contrast, Diacumen was signatory to those contracts that I've mentioned. And so in that context, we'll have a different type of investment that attaches to it. And given that they are different investors with different investments, that affects the type of jurisdiction that the tribunal will have. because the tribunal can only have jurisdiction over breaches in relation to the investments by the investor. So I hope that helps, my lord, but you're certainly right that we will come on to that.
I'm afraid. The Human SE was always a Liechtenstein entity, is that right?
Yes.
So if you're looking at Mr. Starver's interest, you're not looking at his shareholding in DA Human SE as an investment, i.e. DA Human SE is not the investment. He also has been held, hasn't he, to have been an investor in the investments that the award identified, namely the OER letter, the arbitration and the review proceedings. I know there was a lot of dispute about how that would work as a matter of quantum, and you had complaints about that, but that also is all water under the bridge, isn't it?
It is water under the bridge, but I'm happy to clarify for the court. I'll be assisted by those behind me, but I do not recall the award making a finding that the investments in the form of the cooperation agreements with hospitals and the arbitration agreement were investments of Mr. Starver, because he never had a signatory to them or owned those assets. They are investments of Conoco, as it was previously called, before it became DA Human. So in those circumstances, it is not correct to say that those are assets of Mr. Starver. And the reason why I'm proceeding with some caution around this, my lord, is that this is another vexed question when it comes to jurisdiction in investment arbitration. One needs to plead quite clearly, and the tribunal's jurisdiction needs to be founded quite clearly on what the investment is for the claimant. Imagine the situation.
I understand that. I want to know what the tribunal found were the investments that Mr. Starver had.
I will need to take that on notice as to which paragraphs I can point your lordship to. But in terms of your starter question for 10,
yes. It may be my fault. I had understood they were the same for both. The same for both Starver and Diek, but if that's not right, then I must be shown.
And it may well be that it is silent on this question, my lord. That may be the gap between us, in the sense that there was no positive finding that these were investments of Mr. Starver, or distinctly investments of DA Human. Indeed, in circumstances where a tribunal will say we're carrying both claimants forward together, that type of allocation of investments between one claimant or the other as a matter of jurisdiction becomes unnecessary. But that doesn't mean, of course, that there isn't jurisdictional limits attaching to each investor because of the language that we've seen, that it must be an investment by an investor.
All right, thank you.
And if they didn't distinguish between them, then that makes it all the more likely, I'd have thought, that the two cases stand or fall together.
Well, my lord, as a matter of principle, I've explained that the answer to that is no. But for the purposes of this appeal, what matters is the proper characterisation of those issues. And if they are lumped together and dealt with in one, in my submission, that is a further indication that the proper characterisation is jurisdictional. Because there's no doubt in my submission that whether or not each claimant is an investor, and whether or not each claimant has investments by that investor, are jurisdictional questions. So by lumping them together in my respectful submission, that is a helpful approach to the Czech Republic's case. But for the reasons of this appeal focusing only on Mr. Starver, it's not a necessary submission for me to make.
Right, okay, well, you'll develop all that in due course.
I will. I am tempted to move to the case law, but if I can seek the court's indulgence, I think it is important to work through the rest of the treaty.
No, let's do that.
I'm grateful, my lord. Operator, could we please turn to page 5 of the BIT, which is where one finds Article 9, which is the arbitration provision. And one can see, picking up on the discussion that I had with my Lady Justice Andrews, that the scope of the offer in Article 9 is also done by reference to the terms investor and investments, one can see in particular in paragraph 1 of Article 9, for the purpose of solving disputes with respect to investments between a contracting party and an investor of the other contracting party, and without prejudice to Article 10 of this agreement, consultations will take place between the parties concerned. One can see the investor language in the first sentence of paragraph 2. So the way this treaty works is as I've been explaining. The provisions of the treaty do not apply to assets after the putative investor no longer holds those assets. By that time, they are not assets or investments of or by an investor. That does emerge with particular clarity from Article 2, paragraph 1, where the scope of the BIT is explicitly limited to investments in the territory of one contracting party by investors of the other contracting party. And then, as we have seen, that tracks through the substantive provisions in the treaty, Articles 3 to 6 that we saw. And so in my submission, just taking the terms of the treaty, the effect is clear. If Mr. Stava parted with the assets in 2011, then claims for conduct after that date would fail because he could not say that the substantive provisions of the treaty applied from that time. And further, as at the date of commencement of the arbitration, he is no longer within the category of holding investments by an investor.
Can I just, sorry to keep interrupting you, but again, conceptually, the question of when the offer in Article 9 is or can be accepted. Leave aside for the moment the question that matters for us, the subparagraph 2, the arbitration part of it. Subparagraph 1 requires the state, when there's a dispute, to enter into consultations.
Yes.
And that's an offer which is made to do something before arbitration is commenced. So that's an offer which is capable of acceptance before arbitration.
My Lord, if one...
How is that offer accepted?
My Lord, if one is disaggregating the offer for consultations from the offer of arbitration, then as a practical matter, one can see that a potential claimant can seek consultations and be granted them. But in my respectful submission, that would not mean that the arbitration agreement has been accepted. The arbitration agreement is accepted when the consent to arbitration is perfected between the two parties and the arbitration can proceed. Within the context of that arbitration, it will then be a requirement that some consultations have predated the start of that arbitration. But in my submission, that is the containment of a pre-arbitration requirement for consultations within the jurisdiction ratione voluntatis of the arbitration agreement.
So a qualifying investor is not entitled to insist on consultations. Is that what you're telling me? Because if he is, it can only be because there's an offer in Article 9.1 which he's accepted.
If an investor is qualifying, my lord, then yes, consultations.
Right. So that part of the clause can take effect before and without any arbitration.
I missed to start that.
That part of the offer can be accepted before and without any arbitration.
Yes, my lord. Though, mind you, in that situation, the offer for arbitration would itself very likely have been accepted. Certainly the practice is that...
Sorry, go on. No, go on.
Certainly the practice is that an investor communicates with a letter or some other communication to the host state saying, I am a qualifying investor, I accept the offer of arbitration in Article 9, and I would like to consult with you about trying to amicably settle this dispute.
So it's not the commencement of the arbitration itself, it's some separate indication of consent.
I wouldn't characterise it as a separate indication of consent, my lord.
It's not the commencement of the arbitration.
Correct. But I see those.
consultations may be successful.
Correct, exactly.
So
But though-
it's not merely commencing the arbitration that can form the acceptance of the Article 9 offer to arbitrate, so as to complete the arbitration agreement.
I would,
Right so far or not?
yes, that is right. And I didn't mean to suggest that the alternative would be true. But what I was understanding your lordship to suggest is that there were in fact two separate offers in Article 9. And that characterisation, with respect, I would say, is incorrect. There is one offer of arbitration, and once that is accepted, there is a process that one goes through, starting with a period of time for consultations.
But it's not what the article says.
I don't think
I
it's
mean, maybe
consistent.
what people do, but it's not what the article says, because your right for arbitration arises only if you have had consultations which don't result in a solution within 6 months.
Quite, my lord, though mind you, it is still an offer of arbitration in Article 9. This isn't an arbitration agreement that is formed in the way a contractual arbitration agreement is agreed to by both parties at the time of executing the contract. So here, what perfects the consent and creates the arbitration agreement is when a qualifying investor says, I also consent, I accept the offer.
Well,
Is
doesn't
it-
turn on the words request of the investor. I mean, it just seems to me that what you've got, as I understand it, is a contractual arrangement which crystallises when somebody is both an investor and has an investment in relation to anything that they can complain about, which is covered by the earlier articles. And there is already a binding contractual obligation on both parties to consult if a dispute arises. But you only get to an arbitration if the investor then requests one.
So I would agree with that, my lady, and with respect, I don't think that our two positions are at odds with each other. The offer for arbitration can be accepted at any time. Indeed, the moment that I invest in a country with all good intentions and not a hint of a dispute on the horizon, I can write to the host state and say, I hereby accept your offer of arbitration.
But you've got to do something, you say, to manifest an acceptance of that particular offer under Article 9.2, whereas with all the rest of it, you don't need to.
Yes, there would certainly be a world where I could have consultations with my host state's officials about concerns or complaints I have, including that I've been mistreated under the appropriate treaty standards. And that would not by itself constitute an acceptance of the offer of arbitration in here.
No, but the consultations are mandatory under 9.1 because it says consultation will take place. So if the investor turns around to the Czech Republic and says, I've got an investment and I'm not very happy about this, you can't then turn around and say, well, we're not going to talk to you about it.
Well, host states, my lady, do at times say that we are not going to enter into
You'd be in
consultation.
breach of Article 9.1.
And that is a submission that is made in those types
Yes.
of arbitration, certainly. But consultations can happen before an offer of arbitration is accepted and also after.
Yeah.
So in that sense, the reason why I was hesitating with my Lord Justice Popplewell's question is that I do not see those, and I submit it's not correct to see those, as two separate offers. An individual who may or may not be an investor can consult with host state officials at any time, but having accepted the arbitration offer in Article 9, the tribunal will only then have jurisdiction if both parties, the qualifying investor and the host state, have engaged in consultation for a period of 6 months.
It may not matter, but I'm not quite sure why you're cavilling about them being separate offers. If it's open to an investor to insist upon the consultations without saying anything about whether he wants to arbitrate thereafter, is he not accepting the offer in 9.1 on its own?
With respect, my lord, that is the reason I think I'm cavilling is that I would be cautious about establishing a position whereby there are essentially two different offers in Article 9. Article 9 is an offer of arbitration, and consultations may take place before that offer is accepted or after.
Or you could see it as an offer of a two-stage dispute resolution process.
That type of characterisation may be possible, but it would still then be, in that context, my lord, a single offer of arbitration, even if there are stages that need to be worked through in order to ultimately reach the arbitral process.
How's the offer purportedly accepted in this case?
So in this case, my lord, I would need to check. I believe there was a what is sometimes called a trigger letter, whereby a written letter is communicated by the investors to the host state, saying, this is who we are, this is what our investment is, both of which are typically necessary because often the host state has not heard of the investor before that moment. And we hereby accept the offer of arbitration in the arbitration clause in the treaty.
Well, I think it might be helpful for us to have that, actually. So if it's in the bundles,
I'm
that's
not sure
fine.
if it is in the
If
bundle.
it's not, perhaps we could have hard copies tomorrow morning.
My lord, it's not in the core
Right,
or
well,
supplemental bundle, but it is on Opus.
Well,
So
can
we
we have
have
hard
already
copies tomorrow morning,
I'm
please?
sure, my lord. I'm sure.
Okay, good.
So, my lords, my lady, I'm going to stay with the terms of the treaty for just a little bit longer, because I've turned through those and we've had a discussion about some of the effects or the scope of the terms in the treaty. But I wish just to return to the point that is for decision on this appeal, which is whatever the scope, which is a question on the substance of the jurisdictional objection, is it properly characterised as jurisdiction? And if we stay now with Article 9, in my submission, that is the offer to arbitrate in respect of disputes with respect to investments between a contracting party and an investor. So to tie together the points that I've been making in discussion with your lordship and your ladyship, to fall within the scope of this offer, there must be an investment by the investor. And so if the investor has disposed of the asset said to be an investment, then that asset is no longer a qualifying investment for the purposes of Article 9 or the treaty as a whole.
To put it another way, it has to be a qualifying investment by a person who is a qualifying investor at the moment that the Article 9 offer is accepted.
Yes.
That's your case.
Yes, my lord. And perhaps the clearest...
Let's go. And I understand that you say that's what makes it jurisdictional, because if there isn't a link between the person claiming to be a qualifying investor and the investment, at that time the offer is not being made to that person.
Yes.
Therefore, there's no arbitration agreement with that person. I follow the logic that
Yes, my lord.
entirely. What I'm less clear about is whether it's so obviously jurisdictional if you're wrong about that. And what investor means is someone who has formerly been an investor. Because it might be said, if someone has been a qualifying investor in a qualifying investment, and the offer here is to arbitrate with such a person, you then have to say, for jurisdictional purposes, what is the scope of what the parties have agreed to arbitrate? And that's what's governed by the words with respect to investments. I think the argument against you is that includes the question whether someone remains a qualifying investor in relation to that investment.
And
I don't at the moment see why that is so obviously jurisdictional in the way that I do understand on the primary way you say the clause is to be interpreted.
I'm grateful. In the 20...
They don't deal with that immediately if it's not convenient, but I thought I should let you know the way my mind was working on that.
One is always reluctant to allow questions like that to linger in the judicial mind overnight without any answer. So I am going to pause my traversing of the treaty. The last point I do wish to make on that is that the jurisdictional character of the issue that we are discussing, my lord, is, in my submission, very clearly indicated by Article 2.1, establishing the scope of application of the treaty. There's not a possibility that that type of provision is establishing an admissibility rule. It is clearly establishing a jurisdiction rule. And given that the scope of application under Article 2.1 says there must be an investment by an investor, that really, in some respects, is a complete answer to this type
Has
of...
been in this case.
Pardon me, my lord?
Has been a qualifying investor by an investor at this stage. If the offer in Article 9, contrary to your primary case, is an offer to arbitrate with that investor, then you have to say, well, what is it that they've agreed to arbitrate about? And simply going straight to Article 2 to say you have to have a link between investor and investment, doesn't, at the moment, seem to me to answer the question. But you'll explain why that is so.
Well, I'm grateful, my lord. In that case, let's turn to the cases. Because in my submission, that issue has been considered and decided by previous cases. Now, there is no principle of stare decisis in international law, of course. But where the reasoning of a previous tribunal in the investment context is persuasive, then in my submission, that ought to be the line of reasoning that the court adopts. Can I please start with Phoenix and Czech Republic, which is operator at LA6. Now, it's often said in arbitration proceedings such as this that tribunals are constituted with esteemed arbitrators. But in my submission, this particular tribunal is very experienced in the context of investment arbitration, with several hundred decided arbitrations between them. Now, we'll come to the relevant facts of Phoenix in just a moment. But can we start on page 2, please, operator, with the table of contents? One can see, my lord, my lady, that this is an award on jurisdiction. It's setting out the relevant facts on jurisdiction, the parties' positions, and then determining the jurisdictional objections. The relevant section for our purposes is section 4C. And we'll come to that as we turn through the award and its discussion of jurisdiction. We can see throughout this table of contents the Latin names that I've been referring to, which connote the different limitations on jurisdiction of the tribunal. Ratione personae, the personal scope of the treaty, meaning whether there's an investor. Ratione materiae, the material scope of the treaty, such as whether there is an investment. Ratione voluntatis being the scope of the arbitration agreement, and ratione temporis being the temporal scope of the treaty. These are the jurisdictional limitations that apply in the context of an investment treaty. They aren't just treated as such unusually in this award, but rather those are the limitations that apply in investment arbitration generally. Can we please turn to the factual section, operator, at page 10? And the court can see sidebarred there, paragraph 22. One can read that for oneself, but can see the claimant was an Israeli company that purchased shares in 2 Czech companies on the 26th of December 2002. If we go over the page, please, operator, and see paragraph 26. There we can see it's recorded that the claimant sold its interest in one of the Czech companies on 8 January 2008. So about 5 years after the acquisition. And if we go over the page...
That was common ground. That wasn't disputed.
Correct. In that case, yes. We can see that paragraph 26 continues by recording that the claimant sold that Czech company that I just referred to back to the wife of the ultimate beneficial owner. So more of a personal restructuring of ownership rather than an arm's length sale. You can see it in the bottom 3 indented paragraphs. First, the ultimate owner of the seller, i.e. the claimant, is Mr. Benno. Second, we found out to whom claimant sold Bennett Praha, back to the same entity from which claimant bought it in 2002, Mr. Benno's wife's company. And then third, we learned how much the claimant sold it for, and it was $4,000. Now, if we can turn to where these facts were legally relevant for the purpose of jurisdiction, we pick that up at page 29 in the document. This is where section 4C that we saw on the table of contents relating to jurisdictional issues is dealt with. Now, paragraphs 65 and 66 deal with jurisdiction ratione personae and ratione voluntatis. And then paragraph 67 onwards is ratione temporis. And it starts in that paragraph by saying that the claimant cannot assert claims prior to acquiring its investment. My submission, an obvious point. But then if one turns over the page, one sees in paragraph 68 a continuation of the point. It is a matter of jurisdiction to say the tribunal can judge only those acts and omissions occurring after the date of the investor's purported investment. It's in the first sentence. It then continues, the proposition that bilateral investment treaty claims cannot be based on acts and omissions occurring prior to the claimant's investment results from the nature of the host state's obligations under a bilateral investment treaty. All such obligations relate to the host state's conduct regarding the investments of nationals of the other contracting party. Therefore, such obligations of a national of the other state, such obligations cannot be breached by the host state until there is such an investment of a national of the other state. As a result, the tribunal lacks jurisdiction for acts or omissions that occurred before the date the claimant acquired the investment. So it is squarely put as a jurisdictional issue. Now, we don't need to pause on paragraph 69, which notes a similar approach taken in another case. Then paragraph 70 and 71 are important. Paragraph 70 deals with the position after the claimant has disposed of the investment. So the position that we are considering in the current appeal. And this tribunal concludes, the same analysis necessarily implies that the tribunal lacks jurisdiction for acts directed against BP and its subsidiary BG after the sale of BP, and consequently of its interest in BG, to Ben Real on 8 January 2008. As it is not contested that there was no longer any investment of the claimant after that date.
The issue was not in front of them, really. There was no dispute. It's presented as an uncontested fact that there was no longer any investment.
My lady, I accept that in this case, the point about the post-dating side of this was not one that was litigated in full extent. But with this experienced tribunal articulating the position in relation to predating conduct and saying that its jurisdiction is delimited similarly for post-dating conduct, that is, in my submission, a persuasive articulation of the principle. And the reason why this type of case does have extra persuasive force, my lady, my lords, is because there are relatively few arbitrations that consider the position that is before the court now.
But I'm sorry to interrupt you, but I wonder how much this helps us. Of course, I understand classic work by Paulson and how important it is to distinguish between jurisdiction in the proper sense, admissibility or standing, whatever. But that distinction only ever matters when you get to a national court who's deciding whether it has power to step in. So far as the treaty tribunals themselves are concerned, it doesn't really matter whether they describe it as jurisdiction or they describe it as admissibility. They have to decide the question as to whether it is part of a claim which they can give effect to. So in this case, although I accept they used the word jurisdiction, they'd have come to exactly the same conclusion if they'd used the word standing. They just say the treaty doesn't give any relief in relation to conduct, in relation to an investment after you cease to be an investor. But that doesn't help one, at least it's not helping me at the moment, on the question we have to decide, which is whether the tribunal would have had jurisdiction in the proper sense to decide whether the investor had ceased to be an investor in that case. And that would be the analogous case with our case. And I'm not quite sure why this has anything to say, other than you can, of course, point to the fact they've used the language of jurisdiction. But as it seems to me, that didn't really matter for what they had to decide.
My Lord, I certainly accept that in the context of an investment arbitration, the practical effect of describing something as a jurisdictional or admissibility objection can be less than in circumstances where it comes before a post-arbitration review proceeding in court. The Professor Paulson distinction that Your Lordship referred to. But part of the reason why I was prefacing this review of Phoenix and Vöcklinghaus by reference to the terms of the treaty is because in my submission, what is reflected in paragraph 1771 of Phoenix, which is considering similar language to the current treaty before the court, emerges with clarity from the terms of the treaty that I've taken the court to. So I certainly accept that there will be a relative dearth of hardcore analysis in investment arbitration between whether something is characterised as jurisdictional or admissibility for the practical reasons that my Lord, Lord Justice Popplewell has described. But when one goes back to look at the terms of the treaty and look through Article 1 and Article 2 up to Article 9 as we have done, in my submission, what is being delineated there are the jurisdictional limitations on the powers of the tribunal. Article 2.1 of the treaty in particular is very clear about its scope of application, and that is, in my respectful submission, undoubtedly a jurisdictional point. So when one traces from that point through to the decisions, such as in Phoenix, in my submission, determinations like those in paragraph 70 and 71 on the screen are reflective of exactly that treaty interpretation and analysis that we have been through. It is reflective of those being jurisdictional limitations on the powers of the tribunal. If it is correct that Article 2.1 establishes the jurisdictional scope of the tribunal, and I submit that it does, then flowing through that to the use of the same limiting words of investor investment in Article 9, and flowing through that to see how tribunals have interpreted equivalent provisions, is a persuasive basis on which to say the proper characterisation is that this objection is jurisdictional. Your Lordship is correct that the same result in the arbitration would accrue if this Phoenix tribunal said, no, this is an admissibility objection instead of a jurisdictional objection. But in my submission, that would be an incorrect characterisation, both as a matter of international law and for this court to adopt now in relation to the treaty before it.
All right, well, that's very helpful. We will adjourn now and resume at 10:30. Thank you very much.